Welcome back to Skyye Lyfe, everyone. We will start the video shortly. What had happened, y'all? I don't know what that was. My little countdown didn't work. But anywho, welcome back to Skyye Lyfe, everyone. If you are not subscribed to the channel, make sure you subscribe and make sure you hit the notification bell so you get notifications when I put up videos and also when I go live. Make sure that you hit the like button. When you hit the like button, it shares my videos on YouTube. I'm so glad that we now have new information about the Oblock indictment. I will be following this case. As you all know, if you subscribe to my channel, I was following the case of R.Kelly, and I will be following the case regarding the death of FBG Duck, and also known as the Oblock indictment. So we have new paperwork that was uploaded, and I would like to give information, because everybody has, questions and thoughts, and, it's just best to read the actual court documents so we actually know what's going on with the court case and the upcoming trial. So first I'm going to read the charges, and then I'm going to read the joint status report that was turned in. And I'm trying to make some shorter videos. So, because I know this audience, you guys don't really like long videos. So I'm trying to make some short clips for you guys. But also, if you would like to donate to the channel, also these court documents do cost. You could hit my Cash App at $Skyye Lyfe, SKYYELYFE. You could do a super chat, or you could also do a super sticker. All the money for all donations actually go to supporting the channel and to get paperwork, etc. Also, at the bottom of the screen, you can see at the bottom it says for channel donations with the information. Okay, you guys, I'm about to read the charges. Let's see what we have. All right, we have summary of charges. The date was filed September 30th, 2021. Also, you know what? I did one or two other videos on this duck trial, and you need to go back and watch those so you can be current and abreast of what's going on. What happened was the court information was open, and then they closed the docket, so we were not able to get the information because it is an ongoing investigation. And then now recently I looked and I see that there's now more paperwork. Okay, so I'm going to read it. These are the charges against the Oblock members. So it says, first, this was filed. They have count 1 is racketeering activity, murder, kidnapping, offense level number 4. Count 2, murder, violent crime, drugs, machine gun where deaths occur. That's an offense level 2. I'm sorry, offense level 4. Count 3, attempt, conspire to maim, assault, offense level 4. Count 4, racketeering activity, maiming, offense level 4. Count 5, penalties for firearms. Count 6, racketeering activity, maiming, offense level 4. Count 7, penalties for firearms. That's also offense level 4. Okay, so now that I read that, I wanted to make sure you all knew the charges, because sometimes people make up their own charges like they did in the R.Kelly trial. We won't be doing that in this one. You'll have the information. Now, whether you believe it or not, is a different thing. Okay, so now I'm going to read the joint status reports. Okay, what's the date of this? This was 6/3/2022. The United States Court, Northern District of Illinois, Eastern Division, United States of America versus Charles Liggins. And let me explain to you how the court documents work. Where it says Charles Liggins, each co-defendant has paperwork with their name here. This is the one that I pulled up and has Charles Liggins' name on it. Okay, but each of them have their own paperwork in the system. Okay, Honorable Judge M. McLeod. It says joint status report. The United States of America by its attorney, John R. Lausch Jr., United States Attorney for the Northern District of Illinois, respectfully submits this joint status report pursuant to the court's order dated April 6, 2022. Number one, summary of the charges. On September 30th, 2021, defendants Charles Liggins, Kenneth Roberson, Tacarlos Offerd, Christopher Thomas, and Marcus Smart were charged in a 7-count indictment with murder in aid of racketeering activities in violation of Title 18, United States Code, Section 1959A1. Hold on one second, you guys. Okay. Count one. Using, carrying, brandishing, and discharging a firearm during and in relation to a crime of violence, namely murder in aid of racketeering activities and causing the death of a person through the use of the firearm in violation of Title 18 United States Code, Section 924J1. Count two, conspiracy to commit murder in aid of racketeering activities in violation of Title 18 United States Code, Section 1959A5. Count three, assault with a deadly weapon in aid of racketeering activities in violation of Title 18 United States Code, Section 1959A3. Counts 4 through 6, and using, carrying, brandishing, and discharging a firearm during and in relation to a crime of violence, namely assault with a deadly weapon in aid of racketeering activities in violation of Title 18 United States Code, Section 924C1A, counts 5 and 7, CR1. Number two, progress of discovery. The government made an initial discovery production to the defendants on October 28, 2021, followed by additional discovery productions to the defendants on March 7th, 2022 and April 4th, 2022. Now, when you look at that right there, you guys, that lets them know discovery is basically the information that the state's attorney and the investigators are finding to support their case. So it's basically the information of what they have against the co-defendants. So they're saying right now they gave them discovery on October 28th, 2021. Then that means they later continued investigating or had to, get the paperwork together and gave them some more March 7th, 2022, and then did more investigation possibly, and then gave them the paperwork, more paperwork and discovery on April 4th, 2022. Defendants and their counsel are still reviewing the discovery productions, 2 of which were large productions. So they basically saying right here, it was a lot. They gave them a whole bunch of discovery, okay, that they're reviewing. Due to the nature of the charges and the ongoing nature of the investigation, the government may supplement its Rule 16 discovery productions between now and the resolution of this matter. Okay, you guys, I'm not a legal smeagol. I'm not really sure what that means, but I guess it's saying may supplement its Rule 16 discovery protection. I guess to me, it sounds like it's saying that they can continue to provide discovery And as they produce it between now and the resolution of while the trial is going on during the case. That's what it sounds like to me. Don't quote me on it, I'm not sure. Number 3, request for a status conference. The government requests that the court schedule a status conference at which the government plans to seek a trial date during or after October 2023. Dang. That's still over a year out. The government has discussed this request with defense counsel. It is the government's expectation that one or more defendants will proceed to trial. Let's read that again. That might be telling. It says it is the government's expectation that one or more defendants will proceed to trial. So I guess they saying that they expecting a trial. However, somebody might, go ahead and plead guilty. But so far, they all have entered not guilty pleas. While the defendants are still reviewing discovery and have not committed to proceeding to trial, it would benefit all of the parties to block out time necessary to conduct the trial well in advance, given the court schedule and the counsel's other professional obligations. So basically, and it makes sense, they're saying that they gave them the discovery, and it says that none of the co-defendants have committed to proceeding to trial, because this is what happens, you guys. Depending on the discovery, and this is anybody who's been through the criminal system, they're going to show you the discovery basically showing you their hand. Okay, this is what we got against you. And you know how the feds are known to be. We don't know how they are, but how they're known to be. To come to you and give you the option. Either you could turn federal witness, knock some of your time off, or either you could just plead guilty and take this amount of time and not go to court. They're gonna always give options because the goal is to lock everybody up. So, and when we read this paperwork, it says right here, while the defendants are still reviewing discovery. So some of them might read that discovery and be like, they got us, y'all. They got us. They got us. You know what I'm saying? We might as well go ahead and take the plea or cop out. Or they might be like, they don't got nothing. I don't feel that this is sufficient discovery, or they got any type of evidence that's going to get me to be convicted. I'm going to trial. Then you might just have some of them just on GP, just, say I'm going to trial regardless. I'm just not going to cop to a sentence without, at least trying to fight the case. It just depends on who they are and how they move. But let me continue reading. Okay. The court expects the trial will take approximately 4 to 6 weeks. After consulting with counsel for the defendants, it is the government's understanding that the earliest the parties will be prepared to proceed to trial will be October 2023. Dang! Man, y'all, they stretching this out. But I guess, with all this paperwork, people got to read it in time and all that stuff. So we'll see. All right, pretrial motions. Number 4, on October 25th, 2021, the parties jointly moved to stay pretrial. I said it right. To stay pretrial motion filing deadlines until after the capital case section within the criminal division of the Department of Justice had made a decision as to the appropriateness of seeking capital punishment as to any defendant in this case, should they be convicted on count 1 or 2 of the indictment. Wow. So as we see here, they're stating that they made a decision in regards to whether they're going to charge any defendant that gets punished for count 1 or 2 with the death penalty. And from what I recall in reading the paperwork earlier, they said that they weren't going to charge anybody with the death. Let me finish reading. Anybody with the death penalty. CR 61 on January 31st, 2022, the undersigned filed notices as to each defendant that the government will not seek the death penalty if any defendant is convicted on count 1 or 2 of the indictment at trial. Okay, you guys remember I read the counts. Count 1 and 2 was kidnapping and what was it? Kidnapping and activities. Count 1, using, carrying, brandishing, and discharging a firearm during and in relation to a crime of violence, namely murder in the aid of racketeering activities and causing death of a person through the use of a firearm. That was 1. Count 2 was conspiracy to commit murder in aid of racketeering activities in violation of Title 18. Okay. So that's count 1 or 2. So basically using a firearm and then murder and racketeering. Okay, so no capital. Oh, wait. So no death penalty. Notwithstanding, given the defendants are still reviewing 2 large discovery productions, the parties request that the court not set pretrial motion filing deadlines until after the next status date, possibly the status conference that the government is requesting. Oh my God, I have problems saying that word, requesting. If you ever hear me say it funny, y'all, that's the problem. Okay. Defendants agreed to exclude time. The defendants agreed to exclude time under the Speedy Trial Act through the next court date in the interest of justice due to the complex nature of the prosecution and to allow the defendants reasonable time necessary for effective preparation of their defense to the charges. Okay, so it sounds like this is saying they waived their right to a speedy trial because they have so much discovery that they have to read through, and plus they want to make sure that their representatives / attorneys are able to prep properly for their defense. All right, the government conferred with counsel of record for the defendants in drafting this joint status report, and the counsel for defendants agreed to the submission of this joint status report. Respectfully submitted, John R. Laus, Jr., United States Attorney. Okay. By Jason A. Gillian. Okay, you guys. So basically, and they're saying that there was a status report. I looked in there in the dockets, and it was the other day. However, they did it on Eastern time, and I missed it. You know, I thought it was going to be Central time. So the next status report, I'll try to catch it. But look forward to another video that I'm about to create. And thank you for subscribing to Skyye Lyfe. If you have not subscribed, make sure you do so you can get notifications on when I go live and also when I put up videos. And please hit the like button. When you hit the like button, it helps share my video. So I basically determine what I'm going to do on YouTube based on you guys putting comments or you guys communicating with me, and also the likes and reactions to the videos. Also, feel free to put comments in the bottom of the video. Tell me what you think. Tell me what you think if you feel like the Oblock guys are going to walk, or if you think they will get sentenced. You know, just give me an update on how you feel. But please be respectful. All right. Thank you for coming. Thank you for watching my video. I'll get one more up for you very soon. Have a good night.